Hi, my name is Gokul Narayan, and I'm the lead faculty at the Asian School of Cyber Laws. And today I'm in conversation with Advocate Soni Singh, who is a partner at VJ Legal Firms in Delhi and is also a lead faculty for our intellectual property rights course. Hi, Soni. Thank you for joining us today. So today, Soni, I thought we could discuss one of the cases that we were speaking about earlier about disparagement and comparative advertising in the context of the COVID problem that we're facing today. So if you can just begin this discussion with a brief introduction to what comparative advertisement is, and in which context are we talking about this in terms of trademark infringement?
So, comparative advertisement, very briefly, is simply comparing your products with your competitors' products.
Okay.
And normally there is nothing wrong with this, but if you, in the process of doing so, disparage or put down the other person's product, then that's when the infringement kicks in, and
Okay.
the violation of IP law kicks in.
Okay, so comparing in such a manner as to put down your competitor's product is what is prohibited under trademark law, and that's what we're going to be discussing today. So the case law that I wanted to discuss with you today is a very, very recent judgment of Hindustan Unilever versus Reckitt Benckiser. The matter is still sub judice, if I'm not wrong, and you can clarify to us what exactly has happened in the matter. I found it really interesting because A, that it's happened in the context of the COVID, and B, that it's a very, very new judgment. So can you tell our participants what exactly happened in this case till now?
So in this, as you said, this has arisen in the context of COVID-19, taking advantage of the situation. Reckitt Benckiser quickly came up with an ad which said that Dettol hand washes are much more effective in cleaning and in sanitizing the virus rather than any soaps. And immediately, obviously, Hindustan Lever approached the court. Why did they approach the court? Because in the advertisement, there's a bar of soap that is shown as being less effective, and that bar of soap has a particular color, which is red, and has a particular shape, which is very close to Lifebuoy soaps. So evidently, Hindustan Unilever approached the court for a restraint order against this advertisement.
Okay, so what basically has happened over here is that there was a suggestion made in the Dettol ad showing possibly a soap which is red in color and similar looking to the Lifebuoy soap of Hindustan Unilever, suggesting thereby that liquid soaps or hand washes are better at protecting against COVID than bars of soap are. Now, is there any scientific proof behind that, or it was just purely based on whatever advertisement Dettol wanted to do? Is there any scientific backing for this?
At this stage, there was none. At this stage, the court, in fact, never went into this discussion. And in fact, in the background, that WHO has been advising and has been issuing advisories where it is recommended that use soaps to wash your hand. And there's no particular differentiation created between hand washes and soaps. So it seemed kind of baseless, and it seemed kind of open war just to get over this bar of soap, which is almost the most popular soap in the country. So perhaps it was just to take over their market and to use the moment in a very bad manner, as if you may say so, and which the court, I think, took note of.
Okay, so in this regard, there are two case laws which we wanted to discuss today. The first one is a Pepsi case. This is quite an old case, and I'm presuming this is prior to the amendment in the Trademark Act also. So could you just tell us a little bit about this case, Soni?
Yes, so this case is very renowned case and on the issue of comparative advertisement. It is important, and I thought we should discuss this also because this is pre-amendment in the Act, where only unfair trade and competition law could have been used to actually stop and restrain this kind of advertisement. What was the advertisement about? There were basically series of advertisements where Pepsi was shown by Thumbs Up and by Hindustan Coca-Cola to be the Bachcho Wali drink. And obviously not in a direct manner, but in an indirect manner in the advertisement. I don't know if you remember the advertisement. There's a little boy, he's called up on the stage by a celebrity to taste 2 drinks, and he's asked, what do you like more? Like, are you a boy or are you a little boy? So he said, yes, I'm about to be a man, I'm a boy, and I like stronger things. So then he was asked to taste 2 drinks, and then he says one of the drink is much sweeter and tastes like a bachcho wala drink, and one is much stronger and tastes to be like a bado wala drink. So and then they uncover, and one has the brand of Thumbs Up on it and clearly written, and the other one has the blue and red logo, as you can see in the slide, and Peppy written on it, which is very close to Pepsi. So you don't need much imagination to think what is being used in this ad.
So I'm presuming in this case it was held to be disparagement, because this is directly taking on a competition and showing it in lesser light, saying that it's meant only for children, not for adults.
Yeah, so, but it was argued by the best of counsels of the country and on both sides, and it was argued by the defendants that this is normal competition. We are just saying our drink is for older people and this is for kids, and there's nothing disparaging about it, and it is mere competition. There's nothing wrong with this. But courts did analyze the case in very at length and in great detail, and came to the conclusion that when you were saying that something is not meant for someone and it's more for the adults, and it gives a sense of pride to have the drink which is meant for adults, so you are taking away a huge market, you are affecting the market, you are definitely misleading, and you are definitely telling people that, oh, if you're liking the drink which is for kids, then you are a kid yourself. So even older people are being discouraged from having Pepsi.
Correct. I can see that. So this clearly seems to be a case of disparagement. Okay, so what about the next case? This seems to be a little bit more controversial than the previous case we discussed, and it's pretty recent that this case has taken place. Can you tell us a little bit about this one?
So this is a very interesting case. Here, Amul started advertising their ice creams as containing real milk, whereas saying that all frozen desserts do not contain real milk, and in fact they contain vanaspati. So where is the disparagement? You don't refer to anybody else, you don't refer to your competitors, and you are not actually saying anything wrong about anyone seemingly.
Any particular brand?
Yes. But Vadilal approached the court and, Quality Walls. So Hindustan Unilever is owner of the Quality Walls brand, and they approached the court and they made Vadilal a party to it, saying that they also manufacture frozen desserts. We both manufacture frozen desserts, and our products do not contain vanaspati. They do contain refined oil or some sort of oil, but that is healthier than the fat that is used in the ice cream if you are using direct dairy product, or if you're using direct milk in your dessert and you're using fat. So rather than fat, we have refined oil, which is healthier. And vanaspati, if you remember, is related to unsaturated fats which are unhealthy. And if you're saying that frozen desserts contain vanaspati, then it's absolutely disparaging, and it is affecting the entire market of frozen dessert sellers, and therefore we are affected.
Okay, so let me just get this right. So although Amul did not specifically name Quality Walls or Vadilal, what they did end up saying was people who sell frozen desserts use Vanaspati oil. And Vadilal and Quality, since they manufacture frozen desserts and don't call themselves ice cream, directly were hit by this advertising campaign. Thereby suggesting that both Vadilal and Quality Walls also use Vanaspati. And they hit back saying that we don't use Vanaspati, we use refined oil, which is presumably much better in quality than using Vanaspati, and therefore that was the objection.
Yes.
So what was the outcome of this case? What was Amul's reaction to this? What did the court order Amul to do?
There's no direct fallacy in the statement. Amul was using real milk, so there was nothing wrong with that. Amul was not directly telling anyone or putting anyone's brands in their ad and saying that they are bad or they are unhealthy. So the lower court gave a very wide injunction, but the high court said that actually limited the injunction to a certain extent, and said that and that is how Gujarat Cooperative had gone in appeal, because it was the injunction got limited further, and it was said that only the term Vanaspati, you can't say that anyone is using Vanaspati because it does not seem to be the fact. And you are, in that sense, disparaging other products. But to the other extent where they claim themselves to contain real milk, I think the container displayed here in this slide, and otherwise also, Amul continues to say that their products contain real milk.
So the effect of this case primarily was that the part of the advertisement which spoke about frozen desserts having Vanaspati was removed, and the rest of the ad was allowed to continue. So it was found to be disparaging because there was no substantial truth to what Amul was stating, and therefore was made to retract their ad to that extent.
Yes, and that brings us to what is disparaging advertisement. When it is misleading, factually incorrect, then and it is causing harm in the sense of taking away consumers, then it is considered disparaging, and it may be restrained.
Okay.
What is also interesting about this case, we must remember, is by now there is a particular section of infringement which actually talks about comparative advertisement and which deals with such advertisement, which is disparaging or which dilutes the mark of another, to be tantamount to infringement under the law. Whereas before this, and if you see the Pepsi and Coca-Cola case, it was protected under normal common law of unfair trade and competition. Okay,
so now there's, after the amendment to the Trademark Act, we've got a specific provision to deal with comparative advertising. All right. So so in conclusion, let's just sum this up for our audience as simply as possible.
So summing up, I would say that to say I am the best, even if you may not be the best, is all right. But saying I'm the best because the other one is the worst, or he's bad, or he's harmful for you, is what has been restrained. So mere puffing, when you say that you are good, that is allowed. But you cannot discredit or denigrate the other's products. Unless, and if you can support it with facts, but still you can't say that the other's products are bad.
I mean, even if you've got factual references to the fact that there are, I mean, if actually some ice cream manufacturers for frozen dessert are actually using Vanaspati oil, are you suggesting that that still can't be done, can't be said in an advertisement? Because that would be a factually correct statement to make.
If you can back it up with complete
correct.
Facts,
correct.
Perhaps courts can't restrain it.
Correct. So
the same way as defamation. If it's a truth, then it's a truth.
Correct, correct. So basically what we're trying to say is, as long as I keep saying that I am the best, irrespective of what the general perception may be, or the correct status of that may be, as long as I keep saying that I'm the best, there's no problem. You can go ahead and do that all you want to. As long as you do not say something adverse about a competitor, there is no problem. So disparagement.
Absolutely.
Disparagement kicks in as soon as you start talking about the other competitor, and talking about them in a context in which they may be judged by viewers and their potential target customers or their existing customers in a negative light, and therefore be reducing the estimation of them in their customers' eyes. So all of that is disallowed.
Absolutely. Absolutely. You've
All
got
right.
it all right. I hope our viewers have got it as right.
I hope so. I'm sure they would have understood this. So just a note to all of you, please go through the video. If you have any questions about this case law and about generally the concept of disparagement and comparative advertising that you would like to share with us, feel free to write into us or email us, is what I mean. Feel free to email us at any point of time, and we'll try and clarify your doubts. Sony, thank you so much for joining us today on this very interesting case, and hope to see you with a new case very soon.
Thank you. Thank you very much.
Bye-bye.